Oh, hello everybody. Thank you a lot for joining us today. My name is Maria. I am an event manager at Live 99. Live 99 is the most vibrant startup community, and we also run co-working spaces both in Kyiv and in Tallinn. And beside co-working spaces, we'll also do right now online events for the startup community, for the developers community as well, on different hot topics. And that's why we are having an event today with one of our partners, Hetman Partners Law Firm, and we will talk about intellectual property. That's why we are invited Katie Pino, an associate at Hetman, and she will share with us what are the cases right now of connected with the intellectual property, how to protect yourself. And basically, this is one of the most important, probably first steps when you start either your business or a startup to protect your trademark, your property, your tool, online tools, or whatever the product you are developing. So, Katie, the stage is yours. Please tell us a little bit more about yourself and what do you do, and then let's dig into the topic.
Yeah, so hi everybody. My name is Kati Pino. I'm an associate with Hetman Partners. I am mostly advising investments and startups in their different legal needs. I specialize in intellectual property advisory, so I do a lot of intellectual property licenses, a lot of transfers, whatever has to do with the intellectual property. In Hetman Partners, we are focused on advising technology entrepreneurs and also a lot of startups and VC funds and investors. So everything to do with startups. I have a few slides also on this. So all good, I think now. So here are just a few of our clients that we have advised previously. Some of them we are currently advising as well. And why are we into startups pretty much? Well, because investments into Estonian startups are on the rise each and every year. However, in 2019, they were a bit lower than in 2018, but the number of deals was greater. So what you need to know is that this is a very hot topic and a sector on the rise. So what I'll be talking about today is mostly software and very relevant to SaaS providers. So we're talking about coding and the intellectual property to software code and why is this important. So what usually happens is that the people who start a startup, they know each other, or in some cases they are even good friends. So they trust each other and they don't do any agreements. But in most cases, not everybody can do everything. So there is some specialization. So somebody's good at coding, somebody's good at marketing, somebody's good at finances. So everybody does their own track, but there aren't really agreements in place. And everything is based on trust, as I said. And sometimes it's also the problem with this is that the idea or the business takes off instantly. So then you have other priorities like actually doing the business, getting clients, going to accelerators, what have you. So if the priorities are elsewhere, then you just don't make the agreements. And what can happen then? Well, if everything works out well, then you just work with it. You just go with it and everything works well. However, in some cases, if everything doesn't work out so well, Then I have no idea why it doesn't work so well. Okay, so when everything doesn't work out so well, for example, people have different opinions on where to take the business and how to do the business, or sometimes there are pivots or something is not needed anymore. So what's the worst thing that can happen in case there are no agreements and everything is trust-based? Well, the worst thing that can happen is that the one who wrote the code takes off with the code. If there are no agreements in place, then the code belongs to the one who wrote it. So if you don't have any agreements, then the coder can just say that this is mine, I'm gonna take it elsewhere and do whatever I want with that. And the other persons can't really do anything about it. Another bad scenario which can happen is that the coder doesn't do anything anymore. However, no agreements are made. The code is still used for the business. And lo and behold, if everything goes well, the startup takes off. You get hit by a huge damage claim by the coder, because if there are no agreements, the code belongs to them. And if they haven't specifically said that you can use it, then you can't use it. So that's where the damage claim comes into play. What else can happen is that you are faced with a take it or leave it offer by the coder. You either buy them out or they take off with their code and do whatever they want with it. So now we'll talk a bit how to avoid these situations. I'm not telling you not to do business with people you trust or business with friends. What I am telling you is that you should make agreements with everybody that is involved in the business, even if it is your best friend and you have known them for 20 years. Having agreements also helps in case there are some disputes, because when you have it in writing, it's way easier to point that this is what we actually agreed upon, and it helps to avoid disputes. What you should also really pay attention to is agreements with contractors, and especially the IP clauses, because under Estonian law, there is no automatic transfer of intellectual property from the contractor to the person who hired the contractor for work. So you should always pay attention to the IP clauses, that these are included in the contractor agreement. And you should avoid complex IP ownership. So everything should belong to this company that the IP is relevant to. If the IP belongs to some other company, it's quite common that at first the business is done under one company, and then later on it is switched to another company. And this can lead to complex IP ownerships. You should try to avoid it as best as you can. And in such a case, the IP should be transferred from the first company to the other, or there should be a license agreement in place, so it would be clear who has the right to use which IP and under which conditions it is done. What you can also think about is, especially in case of software developments, is maybe it is best to include the software developer in the shareholders, because in case of a shareholder, you can have way more extensive non-competition and non-solicitation provisions applicable than in case of a contractor. And in case of a shareholder, it is also cheaper, but because in case of a contractor, you will need to pay compensation if you want these to be applicable after the contractor relationship has ended. What you also need to pay attention to is the scope of rights that is given in the intellectual property provisions. In the case of software, the most important right probably is the right to make modifications. Unless you have this right, you can't rewrite the code or make additions to the code. So in case of software, it's very important to have it specifically stated that the right to make modifications and to add other works to the intellectual property is transferred to the company. What you can also use is confirmation letters, which just say that, yes, I confirm that I have all the IP rights to this intellectual property and that I have transferred or licensed it to the one that is actually using it. Confirmation letters are important in case of complex ownership because then they make it easier to comprehend. Why is intellectual property so important? Well, in case of SaaS, in case of software products, this is the actual only property that the company has. So unless you don't have the intellectual property, the company is completely worthless. And this is something that the investors also look to when they are doing the due diligence and deciding whether or not to invest into a startup. So if you have the IP clauses down from day one, then it makes it way easier in the process going forward. What can I recommend to you is there are multiple IP license and founders agreements and shareholder agreement templates available. Some are in Startup Estonia. We also have the Lift Hedman page where you can find the templates. And on our homepage, we have articles that discuss different topics that are important to startups and also regarding intellectual property. So, and you can always get in touch with us if you have any specific questions or if you require any additional information, as we are cooperating with Lift 99 on a daily basis. Does anybody have any questions? I don't know how you moderate this.
Yes, of course. Well, we have a question regarding the like the patients in Estonia or basically in EU countries. How much time does it take to apply for a patent and to get it? So, like the whole process, if I'm not mistaken, it takes like a couple of months or even longer. Like at least in Ukraine, but how about that in Estonia and in European Union, for example, as well?
Patent process is a long process, and but patents in Estonia are handled by patent attorneys who are dually qualified in law and engineering. So if you suspect that you have something patentable, then you should get in touch with a patent attorney and they can give you a more specific answer. But in case of a patent, be prepared for a long process.
So, but is it like, if it's the long process, then how many approximate, I don't know, months to half a year? And basically, if you apply for a patent, you can continue working, right? Like you can develop your product, but you have to wait for official document to come to you to confirm that this is your product.
Yeah, I think the timeline is more half a year and even more. But in case of a patent, the most important thing is to file the patent as soon as possible, because you can't have published the technology before you file for the patent. Because for patents, novelty is the most important, novelty and the innovative step. And if you have published the technology, it's not novel anymore, and you can't get the patent. So in case of patent, it's very important to keep your cards close to your chest. So
Okay.
share it on a very neat basis, have NDAs in place, and just make sure that it doesn't leak anywhere before you have filed for the patent.
Okay, what if the team or the company wants to do the pivot and then basically to change the product, then they have to do this procedure all over again? Or if there is some changes in the initial product, like should it be like the renewed patent for the product?
I think it depends on the scale of the modifications. So if the pivot is 180 degrees, then it's definitely a completely new application. But if the changes are a bit more cosmetic, then you might be able to fit these under the previous application.
You mentioned that you have to like sign contracts with everybody, no matter how long do you know the person. Maybe from your practice, from your experience, you know some cases that like was recent ones that actually the code was stolen from a company, or maybe you like, of course you're under NDA and you cannot name the like tell the names, but maybe like how to deal if your code is stolen, right? Like what to do, what's the process, how to prove it's yours and it was stolen by your colleague or employee.
Well, code stealing is quite difficult. I mean, because in case of a code, you have to steal the exact actual code. So you'd have to show that the code is the same, and then that you had it previously. So it's quite difficult, and I can't really say any cases where the actual code was stolen on the top of my head, but I'm sure to some extent these cases exist.
For example, again, based on your practice, did you have cases when the company got back the stolen intellectual property? Like it proved that this is theirs and they got it back?
In such cases that intellectual property is stolen, we usually talk about damages and not getting it back. If it was just copied, then you can sue for damages. Or if you have agreements in place, then you usually have contractual penalties as well, because it's very hard to show how much the actual damage was. I'm not sure how the regulation is under Ukrainian law, but in Estonian law, you'll have to show that you had damage and there was there was the cause and effect. So the damage was caused by this action, and then you'll have to actually show how much damage you had due to this breach or due to stealing the intellectual property. And it's very complicated to show that we actually incurred this much damage, like this many euros. So in most cases, it's contractual penalties, and they are usually quite high, especially since it is difficult to show the exact amount of damage.
Okay. Another question, what about the reverse situation where a contract with a developer has been made, meaning that company owns the rights to the code, but then if a developer leaves, he or she is using the code base to some extent somewhere else?
So in that case, you need to read the contract very carefully. And if all the rights have been transferred to the company, then the company should first send a cease and desist letter to the programmer and say that this is ours and you can't use it. And then the company has available this remedy of saying you should stop this and pay us for the damages that you had inflicted on us due to your use of the code that doesn't belong to you anymore.
Mm-hmm. Got it. Also, in terms of recommendations, can you please recommend any sources that I can read on a conceptual framework for intellectual property education studies?
Ooh. I can't really come up with anything on the spot, but I think there are some MOOCs, like massive online open courses on intellectual property as well. So just I'd say Google.
Okay. How about if, for example, I am a startup and I'm just at the beginning of my road, and I don't really like have a budget for like lawyer consultants and stuff. And where should I start? Either to maybe get a mentor or somebody who would help me to like go through all the process, because basically some of the startups like are very like fresh, and they need to understand like where should they start from or who to go to in cases there is no like budget for example coming to you or to any like law firms.
Well, I think the community events is a great way, because then you get to know other people and more experienced startups, and they will most likely be a very good source of information. Then all the accelerators, and just take part in every event you can. And there are so many online courses or online webinars just as this one. So I think there is plenty of resources, and you just need to start. You need to have the drive to start, and then you'll have it at your disposal. And for actual documents, like for Estonia, the Startup Estonia templates work very well. They might be like difficult to get through because they are legal documents, and some of them have some quite complex language. But you shouldn't be afraid to ask other people. Like, for example, if you have somebody who has done this, then they'll most likely be very eager to help you if you run into trouble.
Do you maybe offer some like free consultancy to some of the startups, or maybe like they can apply and you will like get it like case by case? How it works with you, or you work mostly with the bigger companies?
We have many very early startup stage startups. We offer prizes for like accelerators or some competitions. So that's one way to get like a voucher for our legal fees. We also do a legal clinic in Tallinn Lift 99 Hub, so you can sign up for that. And we have some special deal for Lift 99 members as well. So you just probably need to ask your community manager or something, and they will let you know.
Okay, we have another question. How general or specific does a patent need to be? Do you recommend that the patent start more general to protect your idea and then get more specific with other patents?
Ideas are not protectable. So you can't really protect an idea. If I wanted to do an app for taxi services facilitation, I can do it. Lyft, Uber, and Bolt can't tell me not to, because it's an idea. It's not protectable. But if I take, for example, Uber's layout and Bolt's code, that's another story. So you can't protect an idea. So, and as I understand, I'm not an expert in patent law, but patents are quite specific, because the threshold of actually having something patentable is quite high. So you can't really say like, oh, I have this idea for, making wallets in a very novel way. That's not going to fly.
Okay. Another question. Many companies who did through IP process also go for certification, for example, in finance or medical industry. Do you know what auditors look at during a security audit when they look at the IP compliance?
Well, the ISO standards are quite common, and for some investors they are more important, for others they are less important. I know there are also like standards for cybersecurity and whatnot, but getting certified or getting standardized is quite an expensive process. So before you embark on this journey, you need to like think if this is something that you actually need, or if it's something that will help you tremendously in the future. And if it's worth it, then of course do it. But if it's something that's not super necessary at the moment, then think of it at a point in the future, I guess.
Okay. Just probably like maybe to summary, unless we're waiting for some more questions, what would be your top 3 takeaways that everybody who is listening us now should take with them after this conversation? Like, what first 3 steps should be done, for example, or like what is the most important things that you want people to remember?
I want people to remember that IP is very important. Having agreements on day 1 helps to avoid problems on day 100, and think before you act.
That's very smart. Think before you act. This is like really crucial. Oh, and we got another question. For my startup, if I ask a freelancer to develop the app for me, then after paying off to the freelancer, I want to launch the app under my name. How should I go about it? Should I have any legal agreements with the freelancer? Oh, that's like a very interesting question.
Definitely, you'll need to have an agreement with the freelancer, and saying in the agreement, you should say that all the rights are given to you and all the moral rights are licensed. And this also includes the right to decide whose name to publish with the app, or whether to publish it under any name. So you should have it like specifically said that all the rights to the name and whether to publish it under any name are transferred to you, and then you can do it. If you don't have such a clause, then it's ground for dispute. So better to have it in more detail than in less detail.
Is it some kind of available as like a draft agreement, or you have to come up with like go to the I don't know, associate or attorney and ask for like prepare this document, or maybe like Startup Estonia has the draft, like the template for it as well?
Startup Estonia has an intellectual property license and transfer template, so you can use that. And there are also other templates that have some IP clauses in it, so it's definitely possible to use the existing templates.
Mm-hmm. So, but if we talk about this is if we talk about Estonia, but how about European Union? Maybe you can touch also from this side, if you know, of course. Like if, for example, Estonian or like Ukrainian team wants to get a like I don't know the IP protection in EU, what should be done?
This depends on what kind of IP protection they want. So in case of copyrights, this is automatic in the European Union. So whatever you doodle, whatever you write, that's copyright protected. So you don't need to do anything for that. Mm-hmm. But if you want trademark protection, then there's the European Union Intellectual Property Office, where you can apply for a EU-wide trademark, not patent. So that's a very easy way. If you plan to do business in more than 3 EU countries, I'd say you should register the EU trademark and not local trademarks, because it's cheaper and it just gives you a very wide protection. Patents, there's the European Patent Office, but you also need like local patents as well, because patents is it's very territorial. But for trademarks, you can have EU-wide protection easily. And the application can be done online, so that makes it even easier. No need to go to Spain.
Yeah, so basically, if you want to apply for EU or like have your product developed in EU, then it's easier. But how about other territories? I don't know, if you go to the United States, like probably you have to apply there as well for the like protection.
Yes, for the United States, you also need to register copyrights. So that's different from the European system. If you don't have a registered copyright, you can't defend it in court. That's the US system. So this is something that you need to think about. And like trademarks are also territorial. So if you want trademark protection in the US, you should also register it in the US. If your main market is Brazil, you need to register in Brazil. China, it's quite impossible because everything is almost registered already in China, but you can give it a try.
Okay. So basically, whenever you go to any market you are entering, you have to kind of do this process from the beginning in order to protect yourself on this market.
Pretty much, yes.
Okay. Thank you so much for joining us. There's like lots of huge important information, and yeah, there is another question jumping in, so that's great.
Go.
What about design work? If a startup member did some work based on your wireframes, but they created the actual digital assets, do they or the startup own the assets?
In such a case, then, as I said, you should also have an agreement saying that the add-on work is also belonging to the startup. But if there is no agreement, then the add-on belongs to the person who created it, and the wireframe belongs to the startup. It might be impossible to use the add-ons without the wireframe, so there is some complex questions, but generally the principle is the one who makes it owns it.
Okay. So it's not only about the design work, but all the images and the videos that you do and the photos as well. So
exactly, like every digital media content is the same. So in such a case, it doesn't really matter if it's a designer or whether it's a blog post or whatever. So
got it. If, for example, somebody has a question right after listening this talk, maybe later today or tomorrow, how can they reach out to you? Or should they write to the Hetman Facebook page or maybe to LinkedIn? Like, so if they have a question they would like to get your opinion on.
I am on LinkedIn, and I also answer messages on LinkedIn. I don't know how active our Hetman LinkedIn is, but email is probably the fastest way. Facebook, just like our page, we also share every article and template that we make. So this is one way to get more information as well.
Okay. And again, one more question. We have a SaaS application without defined market, meaning everybody can download and use it. So how to protect trademark and IP in this case?
So it's a born global concept, and the market is worldwide. For trademarks, I think that you will see in a matter of months which markets are the ones that are more viable to you, where you have more customers, and then you should think about trademark protection in these markets that will most likely be the most important to you. If there are only like 2 or 3 people, then might not be worth it to get the protection there. But just think which are the most important ones, focus on those. As you know, the Pareto principle applies pretty much everywhere, that you should put the 80-20 principle. So just keep this in mind.
Okay. And second question from the same person. What about interface? Can it be protected as well in some way?
Like the user interface?
Yeah, probably.
Well, layouts can be protected, and the code behind the interface, that's already copyright protected. So, as I said, agreements.
Yeah. So we shared. Yeah. So this is like the user interface. We shared your like email in the Facebook comments in case somebody wants to contact you right away after this, or maybe get your advice on something. So yeah, I think it was a very productive conversation. Definitely, this is a huge topic, and it has so many details that you cannot like even fit it into like 1 hour or 30 minutes talk. But definitely people should be on the spot of it, and follow all the information that this might be useful for them while developing their product and protecting their product. And thank you for your advices. Yeah, like think before you act. This is probably like the highlight of the conversation, because definitely before doing any steps, you just try to protect yourself. That's like really important in nowadays in the global world as well. Thank you a lot for joining. Lots of thanks from people who are watching us, and we will be in contact, and share any other useful information as well with you later on. Thank you guys for joining and for listening us. We follow our like next events in our Facebook page as well, and stay up to date. And have a nice day.
Bye.
Bye.